We have the privilege of presenting today a risk assessment program with our partner, the University of Florida Levin College of Law Institute for Dispute Resolution, which, as always, in conjunction with Upchurch, Watson, White, and Max, has our back when we put on these webinars, and they're there for your review on our website in the CLE tab, and we'll be good for some time. And we'll give out the number, of course, at the end of the program. But without further ado, I want to introduce my colleague, Frank Bedell. Frank, you want to tell us a little bit about your practice here at Upchurch?
Sure. My name is Frank Bedell, and from 1987 until mid 2012, I was a full-time trial lawyer and litigator. During that period of time, I saw some impressive mediation work done in order to get cases resolved. I became certified, and I was on my own for a while, mediating and arbitrating, and joined Upchurch Watson, White, and Max last year, and I'm thrilled to be here.
All right, and I'm Lawrence Kolin, and I've been now, this has been my 10th year at the firm, but like Frank, started out with my own shop, and I think we both went out on our own from law firms around the same time, and also enjoy resolving cases in state and federal court as well as appellate courts, and doing arbitrations as well. Those are picking up quite a bit lately. And I also write about what we do at a blog that you'll find at orlandomediator.blogspot.com. Been doing that for probably more than a dozen years now. So try to keep the latest trends in mind and keep everybody up to date on that. So today, see if I can move this slide here. We have this topic that Frank and I were kind of discussing what to talk about, and got into an interesting subject area that I think we're all used to doing in the laws, practicing lawyers, and finding things about cases as we go into them. But this is really a helpful rubric that will give us more of a structure to have that analysis. And so we were talking about sort of the academic side of things, and I found Frank had a lot to talk about, so I thought I would help bring this to your attention and have him guide us through this risk assessment process that has been formalized in different areas. CPR has its own version. AAA has put on some programs about it, and then he'll tell us about a group that he went to program on. But yeah, I think this is really a little bit different than our usual fare, and so thanks for coming today, and let's get started, Frank.
Well, thank you, Lawrence. One of the inspirations for today is as I was preparing clients for a mediation as an advocate, I felt like I was doing a good job of preparing the clients, but in retrospect, it seems like I deferred a little too much to the client with respect to risk. And as a mediator, helping the advocates and helping the clients evaluate risk is an essential piece for resolving any legal dispute. And so, so I was speaking with Lawrence about this, and we decided to put on this webinar in order to provide a framework for the advocates, and also to talk to the clients about it. And our webinar and our materials are really designed to promote discussion and consideration as to ways to look at, evaluate risk. The risk of going forward with a lawsuit needs to be considered, whether you're going to continue on in with the litigation, or actually if you're mediating immediately before trial. And so that is kind of the background for this webinar. So the first part of this is understanding, because I know there are a number of different ways, number of different tools and formulas that are used, but we're not talking about, having a specific numerical number. This is more of an art than a science, and the goal is to come up with a way to talk to your client about the lawsuit in a way that you and your client can come to an agreement, or at least an overall strategy. And we'd like for this to be something that is understood, that it is a fluid concept, because as the litigation goes on, circumstances change. You may get a bad ruling, you may get a favorable ruling, and there may be something independent of the litigation which occurs, which will impact how your client feels about their case.
Do you think that this is really available to the mainstream cases? I mean, I know we've seen these tools employed by like in-house departments or insurance departments, and on the other side with large type, class action firms, people that are going to invest serious money into bringing claims in order to figure out, the outcome and cost before they even get going. And now we can sort of scale that to, a normal litigation where maybe the old strategy was sort of, cooperate later and delay now, and rather than try to get ahead of the costs of all the discovery and motion practice. And after a client feels a couple of bill cycles of 30 or 50 grand, they start to say, okay, what are we doing here? And rather get to some of this stuff on the early side where maybe we can learn maybe 80% of what we'll ever know in maybe 20% of that time.
Exactly. As a matter of fact, later on in the webinar, we're going to talk about early dispute resolution and the role that a risk assessment plays in that. But yes, absolutely. I think that this is something that can be done for any case, and that should be done, particularly if the client is going to be investing a serious amount of money or time in the case. Having a grasp on what the risk is, which will include the amount of time that is going to be spent, the amount of money that is going to be spent in discovery, because after you've been practicing for a few years and handled some cases, I think intuitively, when a case comes in, you start to develop a sense of whether your client has a strong case or a weak case. But what we're really trying to do is to help hone that sense into a framework, so that you can present it to the client and have a conversation with your client, so that you and your client are more in line as to how the case is being viewed, so that the client can then have a better understanding as to why you might be doing certain things in discovery, what motions you're going to file, and ultimately all of this is going to be with an eye towards getting the case ready for trial. But here in Florida, the reality is that you're going to go to mediation, and having a better handle on the risk is going to allow you to better prepare yourself and your client for mediation.
Yeah, and I find it at mediation, I mean, everybody wants to know more than the other, right? And people are, um, they're trying to get that knowledge to have power and to be able not only to digest information as it's presented, but then, and whether we're presenting or they do so in opening before we caucus, but then having um, the ability to, use that as it's learned and figuring out probable outcomes. I think we all do that on the fly, and this is really a way to do that as a party exercise beforehand, right? To do that more informed rather than on sort of reactionary basis.
Absolutely. And one of the goals here is to uh, have um, a strategy planned out going into the mediation, or if, almost inevitably, counsel uh, ha have conversations with one another about, uh, hey, listen, we're going to set, 5 depositions. It's going to cost a lot of money. Does your client have any, uh, do they have any interest in, in trying to resolve this case? You don't know when those conversations are going to come up if you don't bring it up yourself, if the other side brings it up. And so thinking about this beforehand is going to put you in a better position to respond to those types of conversations that are brought up by the other side, and also to prepare for uh, mediation. And as a mediator, uh, typically the better prepared lawyer and client will do better at the mediation, because the more preparation you put in going into the mediation, the better you're going to be able to respond to what the other side is doing. And so this is a way to be better prepared as as the lawyer, and also to have a better prepared client going into the mediation.
Okay. And then can we apply it to, towards commercial, like what arenas does it apply to everything?
Yeah, I think it does apply to all cases, and there's certain cases that have sort of similar overall themes, and so we've listed here. You have a tort case, a malpractice case, some kind of accident, and then on the other hand, and this is just broad brush, but you're looking at commercial cases, contract probate, where you have there can be a disagreement as to what exactly occurred, but in most commercial cases or probate cases, but a lot of times it is a difference as to the recollection of what occurs, and how those events are impacted by one side or the other's view of the law or the facts. And or you have a situation where you have uh, parties on the opposite side of a contract dispute, and maybe something occurred that is not directly related to whether or not there was a breach, that is going to perhaps motivate one side or the other to read a contractual term differently from the way they might be reading it if that external circumstance hasn't occurred. But basically, we're just looking at a framework for all cases, so that you can come to a view as to what the risk is going to be ultimately in trial, and then as the litigation goes on.
So I know you're going to get into the meat of the risk assessment, but like just for example, looking at the negligence case, we're going to have to decide what to do with, is there insurance? Has there been a reservation of rights? What are the limits? Is there a coverage defense? Is there indemnity? I don't know, construction case. What do we have with subs? Are there liens? Maybe it's an IP case. We have, is there a licensing agreement? Is there some kind of ongoing business to be sensitive? So you're taking all those things, but you're putting them through this analysis rather than just having them sort of be abstract.
Absolutely. Yes. Yeah, that's a good way of putting it. And as we're going to go into the conversations with your client here in a little bit, but as an advocate, one of the things to be aware of is whether or not your ultimate decision maker with respect to whether the case gets resolved or whether the case gets tried. If the decision maker is also a witness and he or she has a stake in the decision to resolve the case, that is a helpful fact to know as the advocate as you're preparing yourself and your client with for the risk assessment that we're talking about.
Is there a
So
way
it's
to,
helpful. I'm sorry, Lawrence, go
yeah, is there a
ahead.
way to sort of, buffer if you have a witness slash decision maker to get them to get some buy-in on the process that we're proposing here?
I'm sorry, what's that?
Is there a way to buffer the conversation to get them to get off the witness part of the role that they might serve in the case, and to sort of get that objectivism that you're looking for, to take a step back and try and you're going to be making that decision, and we need to look at not just what you know personally about it, but what the other side's anticipated positions might be, what their witnesses might be, what their experts might testify to, and that kind of thing.
Oh, absolutely, absolutely. Multiple times you do have the person who is a decision maker, and a key witness. And I think as a trial lawyer, as a litigator, telling your client, hey, listen, the other side's going to have a different story and a different view of this, and we want you to be as prepared as possible for the questions that are going to come at you during a deposition, for the questions that are going to come at you on the witness stand. And so, let's talk about this from your perspective, but let's also talk about this from the other side's perspective, so that you can do a better job as a witness, and ultimately you're going to make a better decision about the risk of going forward. So before you meet with the client, pull the file out, look at the essential pleadings, just to make sure that your memory is not playing tricks with you. Look at the complaint, look at the answer in the defenses, and think about what the claims are, what facts you know, what facts you don't know, what the key legal issues are going to be. For example, in a contract case, do you have a provision which restricts the types of damages that can be claimed? It seems to me that those are more common these days. Are you going to get a jury trial? Are you going to get or is it going to be a bench trial, or is it going to be, an arbitration? And so looking at that, and then once you have a better idea of what the factual issues are and the key legal issues, then write down so that you can look at it, particularly if you're a visual learner. A likely range of damages, and however it makes sense to you, whether it's a bell curve or or something like that, and then write down for yourself the probability of prevailing on liability, and then if you do prevail on the liability on the plaintiff side, if you're defending, then what are your chances of losing on liability, and then coming up with a range of damages, like I said, and then reduce all that to percentages.
So you have the probabilities of the outcomes. What about the probabilities of the expenses?
Absolutely. That is part of it. If you have a client that is paying by the hour, uh, it's an uncomfortable, but I think it's a necessary conversation to have with your client as to what the fees are going to be. I know here in Orange County, if you're in business court, you have to do a case management report, and you're going to have to put the estimated fees in that case management report. And I
And
think
I
it's better to
Judge
bring
Jordan
this
often
up.
says that they're not enough honest in those reports about how much it really costs.
Oh,
Uh,
really? No, I haven't heard that. That doesn't surprise me.
yeah, I mean, I
Uh,
think people wildly underestimate because maybe they don't want to, have a client say, "What are you talking about?" But also, just I don't think we realize how uh, litigation becomes intractable at a certain point, especially in a forum like that.
oh, absolutely. Absolutely. And what I think is that I think it's much better for these uncomfortable conversations if it's brought up by the lawyer instead of by the client, so you can kind of control how more you can have better control over that conversation, because it's going to happen. You're going to have to talk about it, and you have actually, I think you have a higher likelihood of getting paid in full if the client is better prepared for how much all this is going to cost. Uh, what are your thoughts on that, Lawrence?
Yeah, I think you have to be prepared, and that includes looking when you said like go over the pleadings. You have to go over with them like, look, they have a counterclaim or they have this defense, and it could cost money to kind of knock that one out, or there's things that they haven't figured out yet, but these might be concessions we have to make at some point, and it costs money to get to that point. So I think being forthright, you're right, is better than not. But also just the time and the delay that sometimes happens with things getting rolled or amendments that occur, and then the whole kind of scheduling gets thrown off. And I think those are all areas where neutrals can help. And I think certainly in this process as well, to have, if you're not getting through the client, some discussion with someone who is objective to bring them in and give it a little bit more of a realistic breakdown.
Yeah, that's a good point. One of the things that I like to do as a mediator before we actually mediate is to talk with each side and find out from them whether there's going to be a dynamic at mediation that I need to be aware of, so that I can help them if there is some difficulty with a client, are uh, if there's some background between the parties on each side of the case. It is very helpful as a mediator to know about that beforehand. And in most lawyers, a vast majority are eager to talk about the case before you actually get into the mediation if there is some situation that the neutral can help with. And when you're thinking about before you meet with a client, looking at the case from your client's perspective and figuring out whether there are non lawsuit related factors that might impact how your client is going to view his or her or its risk. If you're thinking about that beforehand so that when you meet with a client and you bring that up, I think that that is an opportunity to build even more trust with your client because you're letting him or her or it know that if it's a corporation or a partnership or whatever, and you have a designated person there, that you're sensitive to and aware of the things that are going on with their business, or whether there are things that are going on with the industry, then I think that that is a good opportunity, as I said, to build trust with the client.
Yeah, and I think there's maybe a misconception that you can't talk to us for some reason. That's always in the arbitration forum, of course, no ex parte communication. But with mediators, we really do appreciate not only advanced summaries, but I try to pick up the phone if I can't get someone these days. People aren't actually at the office so much. Sometimes I'll get a voicemail that goes to some audit system and probably sits there and never gets heard. But I will try to locate the lawyer and have that conversation, and if necessary, sometimes with the client as well in advance, and get to know what those obstacles might be that they're having with their client. It's almost like a mini mediation, flesh out some information, verify some things, but also I try to say, look, you've sent me the summary. I think it's pretty informative. I'd really love you to, even if you have to tweak it a little, share it with the other side. And it helps me deliver some of that news, and they have sort of prepped that by saying what their positions are and having the other side understand them, because it's really, I don't think, Frank, anything to say for trial anymore. I mean, it occurs so rarely. Sure, there's that case or two that has the smoking gun. I get it, but for arbitrations and trial, I just don't think there's much information that the hiding the ball serves a purpose anymore.
I agree with that. As a matter of fact, during mediation, I tell all the parties during the joint session, and then I try to remember to do it at my first individual session. Hey, listen, if there's something that you want to share with me that you don't want the other side to know, please go ahead and share it with me, with the understanding that I will not share it with the other side. And and a lot of times, one party or the other will start to transmit some confidential information, and you can tell that it's happening because their body language changes, their voice changes a little bit, and they'll say, hey, listen, what I'm about to tell you stays in this room. And I'll say, great, yeah, tell me. And a lot of times I've heard, or I will hear, something almost identical in the other room by virtue of the fact that our discovery rules are the way that they are, that typically each side knows what the other side has. And it's very rare that there are situations where there is a smoking gun, but the vast majority of the time is that it's known by the other side. Now, it may be valued differently by the other side, which is fine. And back to one of your other points, Lawrence, with regard to sharing mediation summaries, is It is it is frequently better for a party to hear a tough position from the other lawyer than from the mediator, because I think the other lawyer has the ability to better explain in a way how a particular fact or a particular legal argument is going to undermine what the other side is trying to do.
True. All right, so let's see about when you do this assessment, and I know there are various organizations that have almost like spreadsheets and forms, and you can get
Yeah,
really,
actually, Lawrence, if we could go back to the other slide for just a second. Okay, when you're talking to the client about their risk tolerance, uh, have as direct a conversation as possible. There's a lot of literature out there on how people tend to view risk differently if they're going to recover money versus lose money. And so clients tend to be more risk seeking in one position or the other. But having that conversation directly with the client helps you better uh, know your client, get to know your client, and prepare a strategy for uh, negotiation and for mediation. And just overall is with regard to that strategy, not only do you want to have a particular number or result in mind, but going into the mediation, you want to figure out where you're going to start, how many moves it's going to take, whether you're for a full day or a half day, and then in having a starting number, an ending number, and an idea as to how many moves you're going to want to make. And obviously, you're going to partly be responding to what the other side is doing. But if you can control the narrative of how the negotiation is going, or at least have an influence on how the negotiation is going, then you have a greater likelihood of getting to the place where it is going to be, acceptable to your client.
yeah. And can you talk a little bit about the timing of those moves? So in some cases, you don't want to just go methodically. Maybe you have a couple big ones, and you put the brakes on, or you need some timing between not just going right back with the next offer. How does that affect these kind of things?
It can have, depending on the level of sophistication, the level of planning that the other side has done, it can have a dramatic effect. I've had mediations where uh, where it's clear that one side, and they don't always share, but you have a good feel as to, actually you get a pretty good feel of where you think each side is going to end up, and then you're obviously trying to close that gap. uh, but yeah, you're not, I'm not suggesting, and I'm glad you brought it up, Lawrence, I'm not suggesting that you just you know have a move that is identical to the prior move. But if you have uh, a good starting point, uh, and that's tied to an acceptable endpoint, then you can react to how the other side is making their moves. I had one mediation where it was clear to me that one side knew exactly where they wanted to end up, and you could see it in their moves. And right after lunch, then momentum started to pick up because the party that was better prepared and had a better idea, they were getting close to where they needed to be, and the papers were signed, and everybody was out of there at 2:30 or 3.
And just as an aside, have you found that since the Zoom era of mediation that things tend to go a little faster than they did in person?
Um, Overall, I think yes. I think that yeah, I think so. I think that's a good observation. I think it's harder to just stay locked in uh, when you're staring at a screen. People just tend to get a little more impatient, and they want to they want to cut to the chase. What do you think?
Yeah, I've seen a more sort of economized presentation, a little bit quicker move. But what I like about it is, you usually do get the decision maker, whereas maybe when people were flying around, you got a warm body that needed to make a phone call. So I think that part of it has expedited the running things up the flagpole part of our job. But yeah, it just depends on the case. I think though there is a general trend in efficiency.
Right. Okay.
So let me go to this excerpt here. So, we've tried to understand our risk and what the other side is perceiving as theirs. And I know there's different ways of approaching it. They have very detailed spreadsheets that you can sort of plug in data from your case or whatever. I know you've taken a couple things out of that kind of example to sort of give maybe here in this webinar an idea of what people are looking at. So can you explain this excerpt?
Oh, absolutely. Once you've looked at, you've taken the steps in slides 6, 7, and 8. So you've looked at the case from a big picture point of view. You've looked at the facts. You've looked at the claims and the defenses, how much it's going to cost. And this is an example from a, a non-compete dispute, just an example of some of the intangibles that you would have to discuss with your client from a non-compete case. And just looking at things like for the plaintiff side, why are they filing this lawsuit? Uh, is this to scare off other salespeople who are thinking of leaving? But you have to uh, consider the disruption, because if your customers start or your former customers start getting deposed, then that may have an impact on whether or not they want to continue doing business with you. What is your reputation? Do you need to send a message that you're not going to tolerate people leaving your company and taking data or taking clients or whatever? Is your company a regulated industry? Is your client are they going to have to answer to some regulator if the regulator sees there's a lawsuit? And then with certain cases, you start to have to consider what lost opportunity costs are going to be uh, as employees or even executives have to spend time on litigation matters. And on the defense side, what opportunities are you going to lose if you're taking dollars that would otherwise be spent on chasing new opportunities, and you're devoting those dollars and that time on litigation, obviously reputational considerations with employees, or if this is an individual defendant, with their opportunity to stay working in whatever industry that they're in. And then if there are customers that are up for grabs, whether you have an opportunity to go after that customer when there's not litigation going on, whether there's going to be a better opportunity with that. And then if you have an individual, obviously, who's left a job and she's on a commission only basis, and she can't earn commissions while the litigation is going on.
Yeah, these are all, I think, important factors, and it's good that some of these organizations that put these charts out to almost give you a categoric definition of some things that you might not have thought of. But I think most of us, when you're doing a case, the type of case you know how to do, you're going to come up with these factors from having been through that type of litigation before. But of course, agreeing all these definitions and things is one thing. But when unassisted, without a neutral, can't get sort of through those negotiations, then perhaps we turn to early resolution with the help of a neutral. So um, one of those analysis, I think, can really help to start and sort of jumpstart the conversation, whether or not you have actually a mediation date set or anything of that nature, but rather just to even processes such as early neutral evaluation, which we're seeing more and more of, or the non-binding arbitrations, which are popping up in different jurisdictions, to get sort of that person who's unattached, and they're coming in and they're just giving that objective look-see at your case. But if you're prepared for that, then you've kind of got the ammunition to sort of meet all of those concerns, and where they're weak, you can make those concessions. But it just seems like a really wise thing to have in hand.
Absolutely. That's a good point. And you mentioned before, there are a number of organizations and there are a number of committees and efforts and models. There is the Early Dispute Resolution Institute out of Toledo with lawyers, mediators, and advocates who are involved with that. It's out of Toledo and Chicago and Houston, Texas. The American Arbitration Association partnered with the EDR Institute, and they have been putting on some seminars in terms of early dispute resolution. And an essential part of that, oh, and I should also mention that the ABA recently passed a resolution advocating for early dispute resolution. So, and part of this may be economic, just because litigation is continuing to become more expensive and time consuming. And I think, at least in Florida, a lot of the courts are still working their way through the backlog of COVID. And so if you're going to be in a situation where you might talk to the other side, you might talk to your own client about whether or not they would be interested in seeing if a case can be resolved before a lot of time, energy, effort, and money is spent in order to have a productive early dispute resolution conversation with your client, coming to a general preliminary risk assessment is going to help you with those conversations.
So what is like sort of the knee jerk on pre-suit stuff that goes on between you've got a notice of intent or you've got some kind of demand letter, suit hasn't necessarily been filed, but there's trouble coming, uh, and you get sort of the boilerplate on both sides.
Absolutely. Yeah, no. When yeah, whether you're on the plaintiff side or you're on the defense side, if there has been an accident, if there has been a breach of contract or a non-payment or something that is creating an opportunity or a likelihood that there's going to be a lawsuit filed, typically, depending on the industry, depending on the demand letter, the natural reaction from the client and a lot of lawyers is just to defer that, hey, listen, this is not my client's fault. This is not what happened. We're not even going to respond. Now, if there is a situation where there's going to be let's say that it's the type of accident where there are significant damages or there is an opportunity to resolve something and keep, let's say that both sides reputations are going to suffer if they start suing each other, then those might be the types of things where an early dispute resolution effort is going to yield more fruit than the other situation.
So just going through this exercise, um, even if suit's not been filed, is a way to kind of prepare and better evaluate and to have those things that you'll need in litigation anyway, and it kind of focuses you, right?
Oh, absolutely. Yeah, I mean, this is a step that you're going to engage in anyway. So doing it beforehand uh, is going to create a situation where you, as the litigator, the advocate, the trial lawyer, you're better prepared for what's gonna come, and you can help better prepare your client because the vast majority of situations you have a lawsuit and this visual captures what I would imagine that it feels like from a client's perspective when they find themselves, if they're not an adjuster, they're not somebody who oversees a lot of litigation. There's just a bunch of paper and there are things that are occurring that might not make sense. And I understand when I'm talking about all this, I had a law partner who would assign me cases when I was about a 5-year lawyer, and we'd have the client meeting, and then I'd go back to my office and I'd look at the documents, and I'd do some research and go and talk to my partner. Well, I was an associate at that time. Talk to the managing partner and explain, hey, listen, this is not the type of dispute that the client can afford to litigate because after a year, you're going to be in a situation where you've already spent more in attorney's fees than the amount in dispute. And
Right.
depending on the client, they may not want to hear that, but as he used to say, maybe they needed 2 or 3 months of billing therapy before you have that conversation. Once they know that you have their back, that you're there for them as the advocate. But being there for your client as an advocate also involves uh, helping them understand exactly how much is going to be required of them in terms of time, effort, and money to either prosecute the case or defend the case.
And you mentioned, there are cases where people need to stay in business. They got a dispute going, but they might need each other, vendors or whatnot. And I was looking at the EDR protocols, and I was sort of scoffing because you have this understanding you can develop on the one side, but it really anticipates that people are cooperating almost in like an informal discovery that you'd see in an arbitration, that you have some kind of information document exchange where your ID, the key people in your case that are going to be witnesses, and then some discoverable information. And this slide you have sort of, there's never any meaningful exchange. Is this something that maybe a generational shift is occurring where people are more cooperative? I know in family law they've been trying that for years with the collaborative approach, but is there a chance at having some meaningful exchange because you're going to have to hold hands at the other end of the lawsuit?
Yeah, it just sort of depends, and I've seen those protocols, and the essential part of it seems to me that the essential part of any effort at trying to resolve the case early rather than late is going to require a mutual an agreement on both sides, because you don't want to voluntarily share information if you're not getting anything in return. Your client's going to be angry about that. You might lose some trust that they have. And but if we as mediators get called and the case is early in the process, it has a much better chance of resolving if, even just for the example that you have each side agreeing to share their mediation summary with the other side rather than keeping it confidential.
This is another sort of typical thing where it's like, okay, now we're going to go scorched earth because the lawsuit's filed. We didn't resolve it early. Um, what happens eventually? We're going to have to go sit down. But until that time, either we're going to uh, burn a path and make some money, and then we're going to sit down and talk about it. I mean, what typically happens before there's actually something set in stone that they've got to sit down with us?
Well, it depends on the case, yeah, it depends on what type of case it is, and how the lawyers are getting along with each other, whether the clients have settled in to the idea that there is actually a lawsuit and that there will be a trial if the case does not resolve. But as I mentioned before, in Florida, you're going to go to mediation, and after you've engaged in I don't know how much of the discovery, how many of the conversations that you've had with your client, you've got whatever documents, interrogatories, talk to an expert, whatever it is going to be, the decision maker with the conversation with the client and looking at the types of things that we talked about before, particularly with regard to what the risk is going to be. You don't need to wait until you've done 80%, 90%, or 100% of the discovery to have a decent feel for the strength of your client's case, the weakness of your client's case, as it stacks up against, against the other side. And typically it's, a lot of the mediations that we see are what is referred to as an event-driven mediation. You have a mediation that takes place, excuse me, before each of the principals is deposed, or maybe it's before or after an expert deposition, and those events obviously have an impact, but from my point of view, they more have an impact as to the beginning place for a mediation. In the beginning, one or two offers or demands that one side makes, because the ending point is going to be basically the same, or at least very close to it, without having to wait for a particular event. Now, obviously, there are exceptions to that. If you have a hearing where, for example, an expert is going to be stricken, and the defense is not going to have an expert if the plaintiff succeeds on that. But just from an overall point of view, with prior planning, you don't have to wait for a particular event, particularly if there is a situation where you're having a hard time getting hearing time.
Okay, so to wrap up, what are some of the things that we can do differently?
Well, planning beforehand, and if you're going to have an early mediation, think about what information you have, what information the other side has, what information your decision maker is going to need in order to make the tough decision, and if there is a genuine interest, a mutual interest in a principled resolution, maybe, coming up with a mechanism, and you can involve a mediator with this, for sharing information, and then preparing your own risk assessment and outcome analysis, so that your client has a better idea of what their options are and how much it's going to cost to get there, and then involving a neutral with a formal mediation. But as we talked about before, having conversations prior to the mediation will help the mediator better understand what the case is about, and it will also help the advocates, because they'll understand where the other side is coming from, so that you can talk to your client and have a better conversation about the dispute going into a particular mediation.
Well, folks, I hope that Frank has what your appetite is for this subject, and you can read more about it on several of the resources that Frank mentioned. And if you want to contact us, our emails are on the slide, as is the course number. And for those of you listening, the course number is 240-1630N, as in Nancy, 240-1630N. That's for 1 hour general credit with the Florida Bar. I also wanted to tell you about our upcoming program, which will be May 22nd. We're building out our webinar schedule. This one's going to be called Getting to Green, 7 Expert Tips to Greenlight Your Class Action Settlement. And that's from our Center for National Class and Mass Actions. Again, May 22nd, so look for that in your inbox. And we're right at the top of the hour. I really appreciate everybody. Thank you, Frank. That was interesting, and it does bear looking at this again as a way to get our cases prepared.
Thank you, Lawrence.